watakosana mpaka akose kuongea.
Ini accused wako Ibrahim.
As the council is watching brief for the complainant, and this very afternoon we would like to speak directly to the ODPP. We very much respect the powers bestowed to the ODPP under Article 157. We understand that they are discretionary. However, we are here to remind them that the powers granted to them under Article 157 are not an open check. They should be tempered within the four corners of the Constitution. And Section 4 of the ODPP Act is very clear on the mandate of the ODPP in terms of objects of the law and the policies. So whatever action that the ODPP takes, it must be tempered with reason, it must be reasonable, it must be justifiable, and it must be within the rules of natural justice. It is not an open check that now that they are granted that discretionary power, they exercise it under whims or directions. It is very clear that the ODPP should be independent. And the powers that have been delegated by the ODPP, they should also be exercised with that independence. Our clients were assaulted, grievous harm inflicted on them. The assailants were arrested on the 17th of April. They were locked in custody. Investigations were conducted. The file was properly prepared. P3 forms have been filed. Witnesses, sufficient witnesses, recorded statements. However, at the stage of approving the said charges, the ODPP rejected the file on the guise that the assailants too reported to the police station and their matter was not handled. As we are addressing this specific matter that relies on our clients, and they have a right, the assailants can get their time with the police to have their investigations carried and they be brought to court if actually they feel that they are the ones who have, their rights have been violated. But for our clients, we are telling the ODPP that we are giving them time. The reviews that they have directed the police to conduct. However, we should remind the ODPP that the law grants us an opportunity to institute private prosecution. So if they are going to fail in the mandate that the Kenyans have given them to carry out the investigations, we will follow that channel of instituting private investigation for this specific matter. Reason being, there are two previous cases that have come before court. The same ODPP has withdrawn those matters under Section 87A, claiming that there are no sufficient evidence to have the matter carried through in court. The same as accused persons have now come back again, afflicted our clients, and now when we thought that this time round they would be brought to court, the matter has died off what we can call an artificial death at the level of the ODPP. We are calling for independence in the office of the ODPP, since the police have already conducted their part. So, as we pen off, we are giving an open notice to the ODPP. We are not directing them. We know that we don't have any power to direct them, but we are giving them time, and we are expecting the file will come to the ODPP once again, and this time round it should be, based with the evidence that is available, be approved so that the assailants can take charges in court. Failure to that, we will follow the route of instituting private prosecutions.
Kenyans in this country are still being, their rights are still being violated. We have a constitution that we all fought for in 2010, and nobody is protecting this constitution. Today we have been faced with a very challenging situation where we have people who are Muslims in Takwa Mosque in Jiru. These people were molested, they were fought by a team of goons who are known as Team Kadzo from Isili. These people were hurt. We have very, very disturbing photos that at the right time we are going to put them out in the media. But the prosecution have decided that they are going to withdraw this case at the Odpp stage. We were supposed to have the accused persons availed before court today for charges of grievous harm. We have some of the complainants who are here. They have been treated, but they come to court from the hospital and they find that these charge sheets have not been availed to court. This is very disturbing and it is against any Kenyan's right. Nobody should be violated and the police or the prosecution are not able to prosecute these cases. This is a very good case that should be prosecuted, a case of grievous harm. Penye watu wamekatwa na unakataa kuleta kotini. It is not right. Yes, they have to exercise their rights under Article 157, but again, they should look at victims. The P3 forms are available, the medical documents are available, but you have chosen, as an individual, you have sat in your office and you have chosen not to prosecute these people, not to approve this charge sheet that it will come to court today. So, even as the investigations are going on by the Kayole DCI, it is important that we put this outside there and those who are supposed to be brought to book are brought to book. We have already been informed that some of these accused persons have been elected by SUPKEM and they were former imams of this mosque. And they are not Kenyans, they are actually foreigners and they are here committing criminal activities using the young people in Isili. This is very wrong and it should be brought to book. So as advocates who are watching brief for the complainants in this matter, we are very, very unhappy with what has happened because we have seen other prosecutions happening. How comes these ones for Ibrahim Kadle is not being brought to book? What is so special about this person who is even threatening victims and telling them that tutakuua na tukulipe? How do you pay somebody who is dead? So from 2023, this is a 2023 matter. It has never been prosecuted. It was withdrawn in 2023 under Section 87. Today again, the same Ibrahim has gone ahead to commit other violations. You go to the mosque na unaanza kukatakata watu na visu and then you don't face the law. This is so wrong. And I am calling on the prosecution, the person in charge in the prosecution office, to relook into this file. We are going to give details of the file at the right time to relook into this file and bring these people to book. The police have done their part. They have arrested these people and they have brought the charge sheets to the Odpp for them to be prosecuted. But this is from 2023. This person was, the matter was withdrawn in 2023 and they have gone back in 2025 to commit the same offense at the same mosque referred to as Takwa Mosque in Jiru. He's doing the same thing. He's still controlling the place and he's still harassing Kenyans. So this person has to be brought to book.
Kwa majina naitwa Edin Adhan Leo. Mimi ni victim. Ni mtu juzi ilipigwa na kisu. Leo nilikuja kotini. File kila kitu meletwa na polisi. B3, shahidi, kila kitu tumetiarisha kaletwa hapa Makadara court. Kukuja tu hapa ati tuliambiwa faili yenu hawezi approvewa kwa sababu mkubwa fulani ndio mekanyaga uko juu, DPP ndio mekanyaga faili yenu. So ile mtu anatutesa ni mtu refugee. Hii ni wakati ya tatu, hii ni mara ya tatu. Tumeumia, tumekosa haki. Naona watu inapatoa tu hongo mpaka haki yetu napotea. Hii mtu ametoka Ethiopia, hata juzi hata alikuwa ameua mtu huko akatoroka akakuja Kenya. Na ni grupu ya Hashim, ni mtu ambaye anachinja watu kwa Isli. Sasa wametunyima haki yetu. Polisi imetusaidia, imefanya kazi yao. Sasa DPP amehongwa mchana. Amekanyaga haki yetu. Mtu amepigwa na kisu ndani ya msikiti ambaye imeshikwa, ameletwa hapa. Atanasema hiyo mtu baka mimi nitoe amri asiapprove. So leo tumepata issue, tumepata huzuni, tumesikia uchungu sana. Hapo iko sheria, kila moja iko juu ya sheria. Tunataka serikali iingilie kati itusaidie tafadhali.
Ibrahim Muhammad, mkaji wa Njiru. Mara ya kwanza hii kisa imekuwa December 27 of 2022 ndani ya mosque, takwa mosque ni Njiru. Mimi ni mmoja wao ambayo imejeruhiwa vibaya sana, mpaka kichwa, mpaka mkono, mpaka hapa, kisu na mabanga. Groups ambaye imekondeshwa kutoka Isli inaitwa Team Kazo ndio lotuvamia huko Njiru. Sisi ni wakaji wa Njiru. Baada ya kisa hiyo tulileta mashtaka kwa Kayole Police Station ama DCI. Tulireport everything, B3, everything tuko naye hapa. Kesi ya kwanza ambaye imeshtaki na mimi ndio hiyo DBB walisema hiyo kesi yako hawezi registerwa, ndio hiyo Siad Barre, Abdi Tawane, Ibrahim huyu imam ndio walituchochea. Kesi moja yao ilishikwa naitwa Siad Barre. Tulitoa witness karibu watu 4 walitoa, madaktari wawili, mashahidi wawili. IO ambaye inafunga hiyo kesi ambaye ni mtiamisho ya mshahidi, wakati walitubia 26 June of this year, tulibata tu kwa faili yetu kesi imedorewa na 87A ambaye ilitolewa 25 of March 2025 before court of number 6 before Judge Ombati. Na kesi yetu ilikuwa inaendelea court number 7 na court number 5. Hatujui mpaka sasa kama mimi ni complainant pamoja na IO yangu, hatujui imedoroiwa wapi. Ndio tumekuja leo asubuhi tumejua hiyo kesi, including this one. Ile mwenyewe walitufanya hivyo, pia ndio tena amefanya hivyo. Walibate juzi, yani wametujeruhi vibaya sana. Leo asubuhi jamaa aliletwa, walisema DBB hawezi register hiyo kesi. Tulienda branch ya DBB ambaye ni Makadara hapo. Manager tulienda naitwa Alex, tulienda kwake, alituambia hii amri kutoka juu, kutoka DBB ndio yeye hawezi register. Alisema kutoka juu. Hii mtu ambaye anafanya hivi yeye ni kutoka Ethiopia, inajificha chini ya maskiti. Hatujawahi ona imamu na dunga na kisu na waumini, because tunatoa lawama kwa DBB, hasa Makadara branch including director of Odpp, because alitukanyaga mbaya sana hiyo kesi yetu. Mpaka leo asubuhi tumeshinda kubata haki. So inabidi tuchukue hatua kwa mkono wetu sasa, because kama tutakosa kama tunakosa kwa chini ya serikali ambayo tumekosa haki, itabidi tuchukue na mkono wetu sasa, tuwane huko ndio mambo tena ikuwe zaidi.